23. The case ended in this form, quote, "Under all these circumstances, Sir T. Hislop appeals from the decision of the trustees and the Lords of the Treasury as to the scheme of distribution advertised in the Gazette of the 3rd August 1832 and from the construction put upon the minute of the 16th January 1826 in framing that scheme and the scheme of the 11th March 1828 and from the said minute itself. He humbly hopes that as to the booty comprised in the said scheme advertised on the 3rd August 1832, as well as to all other parts of the booty which remain to be distributed, it will be declared that according to the said minutes of the 5th February 1823 and the 28th June 1825, and the clear and correct statement and recommendation of the trustees as embodied in the last mentioned minute, so much of the said booty as was taken otherwise than in the course of the daily operations of the troops may be distributed amongst the troops composing the army of the Deccan in the years 1817 and 1818, so as that the whole share of the commander-in-chief therein may be allotted and paid to Sir T. Hislop, or in case the Marquis of Hastings shall, in respect of the operations of the divisions of Colonel Adams and Sir J. Malcolm, or otherwise be admitted to share in the produce of the arrears of tribute to the Peshwa, or in any other part of the booty, he may, as to such part, share not exclusively but jointly with Sir T. Hislop for the following amongst other reasons. Quote, Number 1. Because there was no combined army in any manner under the command of the Marquis of Hastings at any time during the war in India in 1817 and 1818, the troops by which the wars against the Pindaris and the Maratha states were carried on in those years having been embodied as two separate armies, one called the Grand Army consisting of 43,687 fighting men and the other the Army of the Deccan consisting of 70,487 fighting men, and because the troops which composed those armies did not, while so separately embodied or while continuing in the field after the dissolution of both armies, carry on any military operations under the general command of the Marquis of Hastings as Commander-in-Chief. Para 2. Because, as Commander-in-Chief of all the forces in India, the Marquis of Hastings had no title to share in any prize or booty whatever. Para 3. Because of the Marquis of Hastings did not hold any military command or exercise any military authority over Sir T. Hislop or issue any military instructions to Sir T. Hislop as to any one operation during the wars against the Pindari tribes or the Maratha states in 1817 and 1818, either in his character of Commander-in-Chief of all the forces in India or his character of Commander-in-Chief of the Grand Army or in any other military character, all the military operations of Sir T. Hislop and the Army of the Deccan having been conducted by him as Commander-in-Chief of an independent army, subject to no control but that of the Governor-General or Governor-General in Council. Para 4. Because the troops through whose operations the booty in question was acquired, either by actual capture or as a general result, were exclusively the troops which composed the Army of the Deccan in the years 1817 and 1818, and Colonel Prodha's detachment. Para 5. Because after the army of the Deccan had been broken up on the 31st of March 1818, none of the troops which then composed it came in any way under the military authority of the Marquis of Hastings, but the operations which they carried on after that time were under the directions of Sir T. Hislop, issued before the 31st of March 1818 as Commander-in-Chief of the Army of the Deccan, and for which alone Sir T. Hislop was militarily responsible as Commander-in-Chief. Because Para 6. Because the Treasury Minute of the 16th of January 1826, as to the 6th paragraph which relates to the share of Commander-in-Chief, makes a decision on a question which was not in any manner argued, to which the attention of counsel on either side was not in any manner called, and as to which there was no evidence produced or required, That decision gave to the Marquis of Hastings an exclusive share of booty which even his council did not claim, and took from Sir T. Hislop rights recognized by the law of price and acknowledged by previous minutes and warrants of the Crown. And the minute embodying that decision as to other parts thereof is also founded on great mistakes as to the law and the facts as to the law in carrying the doctrine of joint or constructive capture to an extent hitherto unheard of, and in considering the capture of booty as not effected until it is actually reduced into possession, and as to the facts, among other things, in considering that any part of the Bengal troops which had composed the Grand Army which was dissolved in February 1818 had been engaged in any one of those operations by which either actually or constructively the territories of the Peshwa had been conquered and the booty captured or acquired. Para 7. Because even if upon any extension of the principle of joint or constructive capture, any part of the Grand Army could be admitted to share in that part of the booty which consisted in arrears of tribute to the Peshwa, if the Marquis of Hastings should, although he had long previously quitted the field, be admitted to share therein as Commander-in-Chief, he can only be admitted to share as Commander-in-Chief in so much of the booty as shall be allotted to the divisions of Lieutenant Colonel Adams and Sir John Malcolm. End of quote. The case which was put in on behalf of Sir L. Smith stated the principal occurrences in the war with the Peshwa, that Sir Lionel was in India at the time of the second argument before the Treasury in 1826, that immediately upon hearing in the July that year of the decision that was to come by that board in the fifth paragraph of their minute of the preceding January, without hearing any counsel, argument, or evidence on behalf of himself or the division he commanded, he transmitted the memorial of the 1st of August 1826, which has been mentioned before, and that he then took steps to procure evidence to show what part of the booty was in Pune at the time he captured it, that a letter was written to Captain Robertson on the subject, who was then collector at Pune and who had been appointed to the civil government of it at its capture by Mr. Elphinstone, and had in that capacity recovered large sums of money belonging to the Peshwa and his adherents, which he had handed over to the price agents. That Captain Robertson replied that except perhaps in the case of the bankers, meaning the deposits by the Peshwa in their hands, he was strongly inclined to think that none of the money he had recovered was in Pune on the 17th of November 1817. That Sir L. Smith again applied to Captain Robertson to assist him in his inquiries, and also applied to several of the principal natives to that effect. The result of these exertions was stated to be that notwithstanding the avowed disinclination of Captain Robertson to take an active part in the business on account of the abuse and calumny which had been heaped upon him in the action brought against him by the representative of Naroba, and the reluctance of the bankers themselves to give any information in consequence of the decision of the Supreme Court of Bombay in favor of one of them, in the case of the Advocate General versus Amarchand, Sir L. Smith forwarded on the 14th February 1828 to the price agents in England the depositions on oath by four of the bankers and managers of banking firms of Pune that 6,72,000 rupees belonging to the Peshwa were in their possession in the city at the time of its capture. He afterwards obtained and forwarded a certificate from Anna Vak, the private treasurer of the Peshwa. The 2,04,500 rupees were in his hands in the city at the same time, and another certificate from the same person, both of which were stated on account of his high rank to have been taken from him without oath, corroborated by the sworn deposition of a Parsi merchant of high respectability that 5 lakhs more of the Peshwas were in the city at the same time in the custody of the house of Dayaram Atmaram, the manager of whose firm had refused to make any deposition unless he received some remuneration for doing so. The case then proceeded to state the opinion of the law officers of the Crown as to the insufficiency of this evidence, and the subsequent proceedings of Sir L. Smith as mentioned ante, page 119. The following reasons were annexed to it. Para 1. Because Sir L. Smith and the 4th Division of the Army of the Deccan were the actual captors of Pune, where the booty in question actually was at the time of the capture of that city, and which booty was recovered in Pune from persons there resident, with whom it had been deposited there previously to the capture of the city, and was there paid into the hands of the civil agent appointed to recover the booty in that city on behalf of the actual captors. Para 2. Because the circumstance that from the forbearance of the troops and the exertions of Sir L. Smith, the city of Pune was saved from being stormed and sacked, and a civil agent allowed to collect and realize the booty instead of the military price agents, ought not to be turned to the prejudice of the just rights of the actual captors, or to have the effect of throwing upon them the burden of that proof which is not incumbent upon actual captors. Para 3. Because, although by the established law of price, the burden of proof in all cases thrown not on those claiming as actual captors, but on those who claim to share as joint captors, or on the principle of constructive capture, yet by the fifth paragraph of the Treasury Minute of the 16th of January 1826, the burden of proof that the booty in question was in Pune at the time of the capture of that city is thrown on those claiming it as actual captors without the suggestion either of any reasonable doubt as to the fact that the booty was in Pune at that time or of any other place where it then could have been. Para 4. Because although the burden of proofs has thus been thrown on the actual captors under the circumstances which made it most difficult to procure any evidence, yet the evidence which has been produced is sufficient, is wholly uncontradicted by any evidence whatever, was unquestioned for years, and is not now liable to any reasonable objection. Para 5. Because the decision appealed against admits another whole army to share in this booty, which was never engaged in any single operation of the war against the Peshwa, but was employed in other wars in a distant part of India. A memorial was subsequently presented to the Privy Council by Captain Job on behalf of the force under the command of Colonel Prother, which captured Raigar, claiming as actual captors the whole of the treasure which had been seized by Captain Robertson at Pune, as having been within the fort at the time of its surrender, and afterwards fraudulently removed by its governor Naroba in violation of the articles of the capitulation. They had previously laid before the trustees the evidence which had been produced for that purpose to the Supreme Court at Bombay and afterwards to the Privy Council in the case of Elphinstone versus Amarchand. This evidence had been submitted by the Treasury to the law officers of the Crown, who were of opinion that the proof was not satisfactorily made out. The Treasury and trustees did not include this force in the scheme of 1832, as they were not furnished with the requisite returns, but they promised to admit it to a participation in the prize money in common with the combined armies under the Marquis of Hastings, and to reserve the competent sum out of it for a future distribution to them. The case was delivered in support of this memorial stated the capture of Raigar, the fraudulent removal of the treasure by Noroba from thence in violation of the terms of the capitulation, and the subsequent delivery up of it to Captain Robertson in the same manner as has been deposed to by the witnesses on behalf of Captain Robertson and Mr. Elphinstone before the Supreme Court of Bombay in the action brought against them by Naroba's representative, and an appendix to this case contained their evidence. The following reasons were annexed to it. Reason 1. Because it had been proved by indisputable evidence taken upon oath in the Supreme Court of Judicature at Bombay that the treasure in question was actually in the fort of Raigar when that fort was surrendered to the force commanded by Colonel Prother. Reason 2. Because the seizure of the treasure took place in consequence of the information transmitted by Colonel Prother to Mr. Elphinstone and by the latter to Captain Robertson of the fraudulent removal thereof in breach of the capitulation under which the fort was surrendered, and because that removal was the only cause or pretext for the seizure. The memorial also prayed that if it should be decided that any part of the booty was to be considered as having been acquired by the general result of the war, the Lords of the Privy Council would advise His Majesty to direct the trustees to distribute to the force commanded by Colonel Prother such a share of that part of the booty as, having regard to the sum which had already been distributed upon the principle of constructive capture, and to the sum then to be distributed upon the same principles, would put the force on an equality in every respect with the other forces who who had shared and should share in such booty for the following reason. Because, according to the true intent and meaning of the general distribution amongst the forces of all the presidencies engaged in the combined operations of the campaign adverted to in the royal warrant of March 1823 and laid down as a principle in the minute of January 1826, the force commanded by Colonel Prother as one of the forces engaged in the combined operations of the campaign was and is entitled to share in such part of the booty as had been or should be adjudged to have been the result of those operations. The memorials of Colonel Doyle, prize agent for the Grand Army, and Messrs. Fletcher, Alexander, and Co., assignees of the Messrs. Alexander, to whom the Marquis of Hastings had assigned his share in the booty, merely stated the various memorials of the other memorialists previously to and since the hearing before the Treasury in 1823. They submitted that the subject matter of them had been fully considered and decided by the Lords Commissioners of the Treasury, the legitimate and constitutional advisers of the Crown in such matters, and they prayed that the recommendation of the Lords Treasury of the 16th of January 1826 and the scheme of distribution of the trustees made in pursuance thereof and submitted by the Lords Commissioners of the Treasury and approved of by His Majesty might stand confirmed and the warrant of the 31st July 1832 be executed for reasons the substance of which was afterwards used in argument by their counsel. Cases were also put in, signed by the law officers of the Crown in answer to the memorials of Sir T. Hislop, Sir L. Smith, and Captain Job. These cases simply stated the various proceedings that had taken place respecting the various claims and submitted that the memorials should be dismissed for similar reasons to those which were annexed to the memorials of Colonel Doyle and Messrs. Fletcher, Alexander, and Co., and were afterwards used by their counsel in argument. All these memorials were referred by orders of council to a committee, of which the members who attended on the hearing were the Lord President, Lord Chancellor, the two Chief Justices, the Master of the Rolls, and the Chief Baron. The parties attended under a summons from one of the clerks of council to attend court on the preliminary question whether the memorials of Sir T. Hislop, Sir L. Smith, and Captain Job ought not to be dismissed without any discussion of the voluminous evidence produced. End of quote. The report of the committee to the King in Council, after mentioning the memorials and the order of the reference, was in these terms. The Lords of the Committee, in obedience to Your Majesty's said order of reference, have taken the said several memorials into consideration, and having heard counsel thereon, and fully considered the same, agree humbly to report as their opinion to Your Majesty, that it may be advisable for Your Majesty to refer the said memorials to the Right Honourable, the Lords Commissioners of the Treasury, to do therein as to them may seem proper. An order of council was passed on the 18th of July 1833 in consequence of this report, referring these petitions to the Lords of the Treasury. Reference, applications were made to the Lords of the Treasury on the parts of Sir T. Hislop and Sir L. Smith that they might be heard before them by council, and the memorandum of the Duke of Wellington in the September preceding the second hearing before the Treasury, and which became first known to Sir T. Hislop in consequence of the motion by Sir Henry Harding after the arguments in the case above reported, was urged as an additional reason, besides those used before the Privy Council, to induce the Lords to grant this hearing. Another memorial was presented to them by Colonel Doyle that the distribution might be proceeded with without further delay. The decision of their lordships upon the question was made known to the parties by letter from the Secretary, the Right Honourable T. Spring Rice, Esquire, to Messrs. McDougall and Bainbridge, agents for Sir T. Hislop and Sir Lionel Smith, in which he informed them that their lordships, having had before them the applications addressed to them by Sir T. Hislop, Sir L. Smith, and various other persons interested in the distribution of the Deccan booty, and also the judgment of the Privy Council, he was commanded by their lordships to acquaint them, quote, that taking these circumstances into their most serious consideration and reviewing the whole course of proceedings, orders and decisions together with the measures already taken to carry these decisions into effect and the consequences necessarily resulting therefrom, they do not consider that it would be just or expedient with reference to the memorials now before them to disturb the judgment already pronounced or any longer to suspend the order of distribution for which a warrant has already received the royal signature. Instructions have therefore been given to the trustees to carry that distribution into immediate effect. End of quote. So that was gross injustice done to Commander-in-Chief Sir T. Hislop. 1st, 2nd and 4th January 1834. On appeal from the Sadr Divani Adalat of Bengal, Raja Haimun Chal Singh, appellant versus Kumar Gansham Singh, respondent. An adoption by a widow after her husband's death without any authority from him is invalid in the Zilla of Etawah in provinces ceded by the Nawab of Oudh in 1801. During the pendency of a suit instituted by a person claiming as an adopted son against a widow, the widow dies and proclamation is made for her heirs to come in and defend the suit, and the claimant is put in possession of the property in dispute by the collector. The court of Sadr Divani Adalat decide that the claimant has not made out his title and direct the collector to put in possession of the property another person who had come in under the proclamation but produced no evidence of his title. Held that the latter part of the decree must be reversed. Mr. Justice James Park. This case comes before their lordships on an appeal from a decree of the Sadr Divani Adalat of Bengal in a suit originally brought by the appellant in the month of December 1810 in the provincial court of Bareilly against the Rani Budhoram for the recovery of the Zamindari or Taluka of Rohroh. The appellant claimed as the adopted son of the deceased Raja Kusul Singh, proprietor of that Taluka, who died about 1775. He claimed by virtue of an adoption which was made about 1778 or 1779 when the appellant was 2 years old by one or both the deceased Raja's widows, Rani Chandar Banse and Rani Budhoram. He also alleged that he had been in possession of the Jamindari and acknowledged as the Raja or Talukdar from that time till the occupation by the British government in 1801 or 1802 of the ceded provinces of which this Zamindari formed a part. He stated that the first triennial settlement was formed with him in that character in 1803 and that on its expiration the original defendant, the Rani Budharam, fraudulently acquired possession and obtained the subsequent settlements. The defendant disputed the fact of the alleged adoption and denied its validity if true, and insisted that the appellant never had the possession of the Zamindari in his own right. Evidence was given on both sides in the provincial court as to the facts, but none in support of the fraud suggested by the claimant, and the opinion of the Pandit of the Zilla court was obtained upon the law, and on the 12th of April 1813 a decree was pronounced against the claim of the appellant. From that decree an appeal took place to the Sadr Divani Adalat in January 1815. Pending the proceedings in that court and in the course of the same year, the original defendant died and a proclamation was made for his heirs to come in and defend the suit. On the 8th of July 1817, the present respondent, who claimed to be the heir of the deceased Raja as his son by a Gundarpa marriage to the seventh wife, and Ratan Singh, who claimed as the son of the daughter of, I think it's Gandharva marriage, were admitted as acting for the deceased respondent. In the meantime, the collector of the district appears to have put the appellant into possession of a moiety of the Malikana rights of the Zamindari in question during the life of the Rani Badhoram and after her death in October 1815 into the exclusive possession of the whole, and this possession appears to have continued until the determination of the suits. The Pandits of the Sadr Court and also the Pandit of the Provincial Court of Bareilly were afterwards consulted. Some precedents were referred to, which form a part of the printed appendix, and the court pronounced a final decree on the 12th of August 1817, by which, in the first place, the division of the Provincial Court disallowing the claims of the appellant was confirmed, and in the second court, it was finally and fully ordered that the property in dispute should, in right of succession, descend to Gansham Singh, the son of Raja Kushal Singh, as the proprietor, that the claim of Ratan Singh should be disallowed. and Ghanshyam Singh is in effect directed to be put into possession of the disputed zamindari. From this decree, an appeal has been made to the king in council, and the case has been argued with great talent on both sides. The two parts of this decree require a distinct consideration. As to the first, the only question is whether, upon the evidence adduced by the appellant and the Rani, he has established a right to the zamindari as against her, and deciding the question, the alleged title of the now respondents, which if true would have prevented the adoption altogether, must be wholly omitted. It has never been proved as a fact in the cause for decision as between the appellant and the Rani, nor indeed for any purpose that the deceased Raja had a child, the present respondent. Upon the evidence, the whole question turns upon the fact of the alleged adoption and its validity according to the Hindu law. Their lordships by no means question the doctrine contended for by the learned counsel for the appellant that uninterrupted and undisputed possession for a long period of time constitutes sufficient prima facie evidence of title. That is a recognized rule of our law, and upon general principles, for the sake of the security of property, seems to be applicable to that of other countries where lawgiver has not specially established a different provision. Nor is it disputed that such a possession, even for a less period than that which elapsed between the year 1778 or 1779, when the alleged adoption took place, and 1805 or 1806, when the Rani obtained the settlement of the Taluka, would have been sufficient to have thrown the burden of disproving the title of the claimants on the opposite party. Whether in this case such a possession has been proved on the part of Hymanchal Singh is very doubtful, but their lordships think it wholly unnecessary to examine the evidence of it in detail, because assuming that the possession was proved, it is perfectly clear upon the appellant's own showing that such possession is referable to his alleged title by adoption and to that alone. If there was no title by adoption, the possession avails nothing. Of the fact of an adoption by the senior widow, no reasonable doubt can be entertained, and therefore the question is reduced upon this branch of the case to the single point whether that adoption was valid in point of law or not. It may also be admitted, on the assumption of the proof of undisputed possession for a long period of time, that every presumption of fact should be made in favor of the validity of the act by virtue of it took place, and that the onus of proving those circumstances which render it invalid in point of law, if the nature of the case requires such proof, ought to lie upon the other side. Does it therefore appear that this adoption was, by the Hindu law in force in this district, invalid? It must be first determined what the provisions of that law are. On the part of the appellant, it is insisted that a widow, and if there be more than one, the senior widow, may make a valid adoption of a relation of the deceased husband, provided it be done with the consent of the nearest relations of that husband, who are the widow's natural guardians, and that if an only or eldest son be given, such gift may be made without guilt in the giver, if made in the particular form called Dvayamushyana, and if not made in that form, yet nevertheless that it is valid when made. On the part of the respondent, it is insisted that the authority of the husband is absolutely essential to the validity of the adoption, and that a gift of an only or eldest son, unless in the above mentioned form, is not merely a violation of the law in the giver, but is absolutely void. The Provincial Court of Bareilly pronounced against the appellant on the ground that though the widow might make an adoption, she could not do so without the consent of her own relations, which was not given. The Sadar Devani Adalat confirmed that decision on a different ground, namely that by law the authority of the husband was essential and that such authority was wanting in this case. Their lordships are now to decide whether that position is correct, and they must decide with the means of information with which they have been supplied, partly from the native authorities in the several courts below, and partly from the textbooks which have been cited in the course of the argument. They are bound to act according to the usual practice and not to advise the reversal of the decree of the court below unless they are satisfied that the decree is wrong, and more especially in which the judge of that court, from his education and habits, must necessarily have more information on that subject than most of their lordships now present can be supposed to possess. Upon a full consideration of these authorities, their lordships are of opinion that they cannot come to the conclusion that the decision of the court below is wrong. According to the native text, it seems to be clear that the ancient law of Hindustan required the authority of husband, but it is also clear that the strictness of that law has be again in any districts relaxed or modified by local usage, and the opinion of the Shastris, as published in Mr. Borodaile's Bombay reports, is very strong to show that in the Maratha states to the West Peninsula, the law does not require any such authority to render the act valid. But that such relaxation has extended to this particular district is not, in their lordship's judgment, established. On the contrary, the weight of authority is in favor of the opposite conclusion. The opinion of the Pandits of the Sadar Court, both in this case and the case of Shamsher Mal, Appendix 83, and that of the Pandit of the Provincial Court of Appeal of Benares in the latter, appearing to be entitled to more credit than those of the Pandits of the Zilla and Provincial Courts of Etawah and Bareilly and of the City Courts of Benares. Without pretending to decide what is the law in other districts of India, their lordships feel bound to say that in this particular district, upon the authorities brought forward in this particular case, they must pronounce that the law requires the direction of the husband in order to the validity of an adoption. At all events, they cannot say that it does not, which they must do in order to reverse the judgment. Was then such an authority given in this case? It is clear from all the evidence that it was not. There is no evidence of any kind leading to the supposition that it was. The interval of 4 years which elapsed between the Raja's death and the adoption raises a strong presumption that his authority was not given. For if it had been, a direction so important in a religious point of view would naturally have been carried into effect much sooner after his death. And besides, not one pleading or document on the part of the appellant at any stage of the case suggests that such an authority was given. Their lordships therefore think, upon this view of the law, that upon the evidence in the case it clearly appears that the adoption was invalid, and the title which rests on that adoption and was the foundation of the suit being for this reason invalid, the appellant must fail in the suit, and so much of the judgment as affirms the decree of the court below must be itself affirmed. It is unnecessary to determine whether the other objections to the adoption were well founded. Probably they were not. The second part of the decree, which establishes the right of the respondent and in effect directs him to be put into possession of the zamindari, cannot, in the judgment of their lordships, be supported. It was contended that the appellant had no interest in that part of the decision and could not be heard to complain of it. But in truth, he had an interest, at least it is not clear that he had not. If he acquired no right to the possession subsequent to that right upon which he founded his plaint, he could perhaps have had no ground to complain of a decree which, after negativing his claim, affirmed that of another. But as he certainly acquired a possession of some sort by lawful authority, if the collector's statement in evidence in the cause be correct by a grant from the executive government after the Rani's death, that title should not have been disturbed by the decree of the Sadar Court establishing the right of another who was not for this purpose a party to the cause, but the appellant should have been allowed to retain possession as far as that court was concerned, and the executive government which gave the title should have been left free to allow it to continue or to be taken away as it thought fit. That title was not given upon the footing of any preceding decree which was reversed. It probably was bestowed because the appellant was supposed by the government to be the adopted heir, and the language of the collector's report was in favor of that supposition. It may probably have been because the zamindari was deemed a bonum vacans and the appellant was thought a fit person to receive the grant. In the former case, it was fit for the government to rectify the mistake by withdrawing the grant after the confirmation of the decree of the provincial court and granting to whom it pleased. In the latter, the appellant ought to have been permitted to continue in possession, subject to be dispossessed by anyone showing a title not barred by lapse of time. But the court of the Sadar Divani Adalat had no right to determine the question of the title of a third person, for it was not the question in the cause at all. And that part of their decree which has this effect, their lordships will recommend to His Majesty to reverse, and after that reversal, the executive government will deal with the possession as it thinks fit. The decree must be affirmed in part without costs. 3rd January 1834. On appeal from the Sadar Divani Adalat of Bengal, Sir James Gordon, executor of Fateh Yab Khan, appellant, versus Khaja Abu Muhammad Khan and others, respondents. a suit instituted in 1817 to recover Althamgha lands in right of an ancestor who died out of possession of them in 1798, held to be barred by the by the Bengal Statutes of Limitations, Regulations 3 of 1793 and 2 of 1805. The facts and previous decisions in this case are fully reported in 4th McNaughton Sadar Diwani Adalat Reports, page 137, new edition, page 173. The arguments before the Judicial Committee by the counsel for the appellants were principally those used by the second judge of the Adalat Court, Courtney Smith, Esquire, in his judgment below, in which he dissented from his colleagues. And they also endeavored to prove that according to the true construction of the regulations of 1793 and of 1805, the appellant's claim was not barred. Bickersteth, Casey, and Lushington Doctor, with whom was Manning for the appellants, Spanky, Sergeant, and Lloyd for the respondents, Vice Chancellor. In this case, the lordships are of opinion that it is not necessary to hear counsel for the respondents, for they have all agreed that in any way of putting the case, the appellants are barred by length of time according to the terms of the regulations of the government of Bengal. If the appellants think that they can rest their claim on the Mohammedan law of inheritance, independently of the arguments that have been drawn from the construction attempted to be put on the words of the decree of 1777, then it appears that Nadira Begum died in the year 1798, and there is no reason whatever why her heirs might not have brought their suit prior to the year 1817. But if they put their case on the ground that by the decree of 1777 she is to be considered as having acquired a right to the fourth part of the inheritance of her husband, we must look at the terms of that decree. Now the decree of 1777, as it is set out in the printed papers, directs, quote, that as to the Altamga Mahals, Bahadur Khan shall, on the part of Alam Beg, hold and keep possession and occupation of them, and shall annually give to Masammat Nadira Khan during her natural life 3 shares of 12 as aforesaid from the produce of them. End of quote. And it is remarkable that on looking at the case referred to by the counsel for the appellants in McNaughton Sadar Adalat reports between Omar Khan and Muhammad Khan, which was a cause between the heirs of Alam Beg, there seems to be a translation from the Persian of that very decree of 1777, which represents that the Altamga, according to custom, were to be delivered over to the charge of Bahadur Khan, who was to allow the widow 1/4 of the produce for her maintenance. End of quote. Their lordships are therefore of opinion that upon the true construction of the decree of 1777, Bahadur Khan was to be considered as only the depositary or agent of Alam Beg, who was the heir of the deceased husband of Nadira Begum, liable to the obligation to pay to her for her life only the produce of 1/4 of the inheritance. And it is plain, upon looking at what took place in the case of the dispute between the heirs of Alam Beg, that the right of her heirs to inherit after the expiration of her life never was in any way acknowledged. Their lordships are of opinion that the regulation of 1793 directly applies to this case. It is impossible to bring this case within the 4th section of the regulation of 1805, because it cannot be truly said that Bahadur Khan was a mortgagee or depository for Nadira Begum, otherwise than as he was subject to pay to her 1/4 of the proceeds during her life. And this being their lordship's opinion, the consequence is that the decree of the court below must be affirmed. As it appears, however, that there was some variance in the opinions of the judges of the court below, and of the reasons upon which the judgment appealed against was ultimately given, we are of opinion that it should be affirmed without costs. Mr. Sergeant Spanky observed that as the suit had been carried on by the East India Company on the part of the respondents at the suggestion of the Privy Council, they ought to recover their costs from the respondent. A doubt might exist on the subject, as they had undertaken this suit before the passing of the last Privy Council Act. The court recommended a petition to be presented on the subject. 4th, 6th and 8th January 1834. on appeal from the Sadar Diwani Adalat of Bengal. Gopi Mohan Thakur and others, appellants, versus Raja Radhanath, respondent. Money advanced to the guardian and agent of an infant zamindar to pay the arrears due to government on account of his zamindari is recoverable in the Mufassal courts from the zamindar, although the leaders took a bond sorry, although the lenders took a bond in the English form for it from his guardian and agent in their own names without any mention in it of the Zamindar, and sued and obtained judgment against them personally in the Supreme Court at Calcutta upon the bond, and took one of them in execution under it. A statute restricting courts of justice from hearing and determining suits upon certain contracts and not entered into without the consent of government and not registered in a particular manner does not render those contracts illegal, and therefore when that statute has been repealed, such contracts may be enforced in courts of justice although entered into whilst the statute was in force. Mr. J. Bosanquet. In this case, a suit was commenced in the year 1796 in the Zilla Court of Dinajpur by the appellants representing Darp Narayan Thakur and Banarasi Ghosh, who were money lenders at Calcutta, against Zamindar Raja Radhanath to recover a large sum of money amounting to 80,150 rupees alleged to have been advanced by them in 1780 for the use of the Zamindari during the minority of the Zamindar to two persons named Janaki Ram Singh and Sadanand Sarkar, who were the lawfully appointed manager and vakil of the Zamindari. The principal part of this sum was said to have been advanced for the purpose of enabling those persons to pay the kist then due from the Zamindar to government, and to have been actually received by government in the discharge of the kist. To secure the money thus advanced in 1786, a bond in the English form was given by Sadanand Sarkar, the Vakil at Calcutta, to an English gentleman as a trustee for the lenders, and the amount not being paid, another bond was given for the same amount with interest in 1787 by Janaki Ram Singh and Sadanand Sarkar to the same trustee, who in each case signed a declaration of trust in favor of the lenders. The first bond was not put in suit, having been given up, but the money not having been paid, the two obligors in the last bond were sued upon it in the Supreme Court and taken in execution, and Janaki Ram Singh died in jail. The Zilla Court dismissed the suit against the Zamindar. On an appeal from the decree of the Zilla Court to the Provincial Court, much evidence was given which had not been laid before the Zilla Court. The former decree was reversed with costs, and the Provincial Court determined that the Zamindar was liable to pay the sum of 60,300 rupees, the amount for which the bond was given, together with interest equal to the whole principal, making together 1,20,600 rupees, the amount of the penalty of the bond. That court being of opinion that whatever loan borrowed in the time of Janaki Ram Singh or of any others Sarbarakar, the Zamindari, should be proved to have been actually paid into the treasury, was payable by the Zamindar from the Zamindari, and being also clearly of opinion that 60,000 rupees paid by the money lenders was received into the treasury on account of Zamindari. The sum of 300 rupees in addition to the 60,000 rupees, the amount of the loan, appeared to have been the expenses attending the transaction, being just 1/2% upon the loan, and the provincial court seems to have considered the amount of the obligation upon the Zamindar as commensurate with the penalty of the bond. On appeal to the Sadar Diwani Adalat, the decree of the provincial court was reversed and that of the Zilla court affirmed. The only reason for this reversal, which is distinctly expressed by the judges of the Sadar Diwani Adalat, is founded upon the later part of Article 20 of the regulations of July 1781 and June 1787, which they say was overlooked by the provincial court when referring to that article, which, after prohibiting the courts of justice from determining any suit against any zamindar, talukdar, chaudhry or other holder of land, being malguzari, unless it should be proved to the satisfaction of the court that the money originally lent or arising from such other valuable consideration was for the service of the zamindari, talukdari, chaudhry, or other land and actually paid to the government as part of the revenues thereof, proceeds expressly to prohibit the courts of justice from passing any decree in any suit against a zemindar or other landholder of Malguzari land concerning any debt, contract, bond, or other engagement concluded by them after the 1st August 1781, unless proved to have been contracted with the previous sanction and consent of the Committee of Revenue, and that a note or memorandum specifying such consent had been registered in the Sadar Kanungo's office. The judges of the Sadar Divani Adalat do not express any opinion upon the effect of the evidence or any dissatisfaction with the conclusion drawn from it by the provincial court, but found the decree of reversal upon the clause of the regulations which had not been noticed by the provincial court, and they state no particular objections to the principle of the decision of the provincial court. They simply add a remark, possibly and I think most probably in allusion to the effect of the clause supposed to offer an insuperable impediment to the suit, that the suit was not instituted until Janaki Ram Singh had died in jail, where he was confined on account of a decree obtained against him in the Supreme Court for the amount of the bond, the subject of the present action, and that the natural inference to be drawn from this fact is that the respondents in that court did not at that time conceive that they could maintain any suit at law on account thereof against the appellant. The case has been argued both upon the effect of the evidence and upon the law. The evidence is alleged by the respondents to be insufficient to support the conclusion of the provincial court, and the appellants insist that the clause of the regulations relied upon by the Sadar Devani Adalat was rescinded at the time when the suit was commenced, and consequently that the appellants were at liberty to pursue their remedy as if the clause never had existed. Their lordships are of opinion that the evidence laid before the provincial court sufficiently established that the sum of 60,000 rupees was advanced by the persons whom the appellants represented by the means of hundi or bill of exchange drawn in the name of Ganesh Das of Calcutta in favor of the collector at Murshidabad and received into the treasury of the government on account of the kist due from the zamindari of Raja Radhanath and paid when due. And they were also of the opinion that upon the evidence this sum must be taken to have been advanced not to Janaki Ram Singh and Sadanand Sarkar or either of them in their individual characters or upon their own account, but advanced to them as manager and vakil of the zamindari, and consequently, according to the law prevailing among the natives of India, became the subject of demand upon the zamindar for whose benefit it was advanced. The hundi was given by the shroffs or money lenders at Calcutta to Sadanand Sarkar, who was the vakil of the zamindari. Both the money lenders went with him to the Khalsa or treasury to see the hundi delivered to the proper officer of the revenue, and the vakil alone in the first instance gave any bond by way of security to the lenders. The payee named in the bond was an English gentleman, a mere trustee to the money lenders, whose name was introduced for the purpose of enabling the parties interested to sue in the Supreme Court, and the omission of the Raja's name and of any mention of the zamindari in the bond, as well as the omission to obtain and register the consent of the Committee or Board of Revenue, may well be accounted for from the apprehension that the introduction of any matter apparently relating to the revenue might prejudice the right to sue in that court, and consequently retard the remedy there of a judgment on the bond. It has not been suggested that the money was advanced on the personal account of Sadanand Sarkar, the vakil, nor is it likely that it should have been so advanced. And if it was to be advanced for the personal benefit of Janaki Ram, it is very improbable that the bond should have been taken from the vakil of the zamindari only. The bond not having been discharged, another bond was required in the following year, both from both Janaki Ram and Sadanand Sarkar, but the question to be determined relates to the money advanced in 1786, for if the money then supplied was advanced on account of the zamindari, the joint and several bond given as a security in the ensuing year will not vary the nature of the loan or discharge the liability of the zamindar. No evidence was adduced on the part of the respondent to rebut the that the money so advanced to the vakil with which the kist of the zamindari was actually discharged was advanced for the benefit and on account of the zamindari. And though it has been remarked that the delay of the money lenders to commence any suit against the zamindar after the death of Janakiram affords reason to suppose that they thought they had no right to do so, we do not know when the Raja came of age or what was the condition of the zamindari from the time to the commencement of the suit by the appellants in 1796, about 4 years after the death of Janakiram, or what was the state of the families of the lenders who died between the and the commencement of the suit, or how soon the apprised that they might sue the zamindar with the prospect of success in consequence of the impediment to their suit which existed at the time of the transaction having been removed. The real question is whether the money was expressly advanced for the use of the zamindari or generally for the use of those who received it to be applied as they might think fit, and their lordships are of opinion that the circumstances which accompanied the loan in the first instance, when the only security so required was that of the vakil of the zamindari, a person of very inferior status when compared with that of Janaki Ram, the uncle of the zamindar, and the precaution taken by the money lenders of accompanying Sadanand Sarkar to the Khalsa to see the hundi delivered to the proper officer of revenue are sufficient to decide this question and to show the transaction to have been of the former character. If then the circumstances of the case establish that the money was borrowed on account of the zamindari and was paid to the government on that account, the bond given by the Sadanand Sarkar to a trustee for the lenders in the English form for the purpose of enabling them to enforce a personal engagement of the vakil in the Supreme Court will not deprive the lenders of their rights under the law prevailing among the natives in matters of contract to sue the zamindar in the courts of the Mufassal. The remaining point to be considered is whether the government regulation of 1781, which was in force at the date of the loan, and that of 1787, by which it was continued until 1790, had the effect of depriving the appellants of their right to sue the respondent in 1796. If, according to the true intent and meaning of the regulation of 1781, it operated as a prohibition of any such loan as that upon which the suit is founded, without the consent of the committee or board of revenue registered as therein mentioned, the loan itself was illegal, and the subsequent repeal of the regulation would not give a right to sue upon it. But if it amounted to nothing more than a restriction upon the jurisdiction of the court over transactions of this description, unless sanctioned and registered as also mentioned, the repeal of the restriction will open to the parties the right to seek any remedy in the court which, according to the general principle of the law, would be applicable to their case. There is nothing in the regulations of 1781 or 1787 which, either in the terms or the spirit of them, appears to their lordships to make it illegal for a zamindar to contract a debt or for any other native to take an obligation from a zamindar without the consent of the officers of revenue. Such an obligation, if founded on a valuable consideration, would have been equally binding upon the conscience of the zamindar, and the demand and the payment would be equally legal as if such consent had been obtained and registered, though no court of justice might have jurisdiction to enforce the right. Whatever may have been the notions of public policy upon which the native courts were for some time restrained from taking cognizance of such transactions, those notions have not been deemed upon experience to have been well founded, since those parts of the 20th article of the regulations of 1781 and 1787 upon which the court of Sadar Diwani Adalat rely have been expressly rescinded by the regulation of the 29th of October 1790. The title of a regulation passed The title of a regulation passed in 1793, number 38, has been referred to, which commences in these terms, quote, a regulation for enacting with modifications such parts of the rule passed on the 27th of June 1787 as prohibits covenanted civil servants of the company employed in the administration of justice or the collection of public revenues lending money to zamindars, independent talukdars or other actual proprietors of land. The language of this title appears to treat the restrictions contained in the regulation of the 27th June 1787 as amounting to prohibitions And in a popular sense, the law which deprives a creditor of his remedy may be considered as prohibiting him from taking an obligation to pay him. But unless such be the true construction of the regulation itself, that sense cannot be imposed upon it by the language of a subsequent regulation, not expressly declaratory, much less by the title of a regulation only. The regulation of 1793, in modifying that of 1787, prohibits in express terms whatever is intended to be forbidden. Those of 1781 and 1787 are only restrictive of jurisdiction, and if they were construed as amounting to prohibition, the extent of transactions which they embrace would lead to consequences highly inconvenient and unjust. Their lordships, therefore, are of opinion that a report should be made to His Majesty by the Judicial Committee and recommending that the decree of the Sadar Divani Adalat Court be reversed and that the Court of Sadar Divani Adalat be directed to affirm the decision of the Provincial Court, but without costs, as a difference of opinion has prevailed amongst the courts below, and that for the same reason each party should bear his own costs of this appeal. The order must provide for the reimbursement of the costs incurred by the East India Company in prosecuting and defending the appeal. Page 46. 6th and 8th January 1834. On appeal from the Supreme Court at Calcutta, the Bank of Bengal appellants versus the East India Company respondents. In an action against the East India Company by the holder of a forged imitation of one of their promissory notes issued by the Governor General in Council at Calcutta, held that the company were not bound by the acknowledgement of it as genuine by a clerk in their Accountant General's office, who was authorized by the Accountant General to compare all such notes with the register, but not authorized to certify their genuineness, although it appeared that it was his practice to do so. The facts of this case are so fully stated in the judgment as to render any recapitulation of them unnecessary. It was decided without hearing the counsel for the respondents. The Solicitor General Sir J. Campbell, Mall, Casey, and Creswell for the appellants. The Attorney General Sir William Horn, Sir J. Scarlett, Casey, Spanky Sergeant, Wigram, and Lloyd appeared for the respondents. The Chief Judge of the Court of Bankruptcy. This is an appeal from the judgment of the Supreme Court of Judicature in Bengal in an action of assumpsit brought by the Bank of Bengal against the East India Company to recover the interest alleged to be due to the plaintiffs as endorsees and holders of 3 promissory notes made and issued by the Governor General in Council as agent for the defendants. The plaintiffs were non-suited at the trial, and upon motion to set that non-suit aside and to enter a verdict for the plaintiffs, the court held the non-suit right, and judgment was entered for the defendants accordingly. The plaintiffs have appealed to the King in Council, and the question is whether the plaintiffs were entitled to recover. It was proved at the trial that the instruments declared on were forged imitations of genuine notes issued by the order of the Governor General in Council, to secure to the holders the repayment of monies raised by way of loan for the public service of the company and the payment of interest quarterly in the meantime. That upon these notes being brought to the plaintiffs for discount, they sent them to the office of the Accountant General, where the company's notes are prepared and registered for the purpose of ascertaining whether they were genuine, and that Mr. Oxborough, a clerk in the Accountant General's office, whose duty it was to make and keep the registrar of the company's notes, examined the notes in question, and being deceived by their appearance and their corresponding with the entries in the register, wrote his initials on the margin to indicate that they were genuine, and that the plaintiffs, relying upon Mr. Oxborough's certificate, discounted the notes. The appellants therefore contend that such certificate certificate amounted to an acknowledgement by the company that the notes had been issued by their authority, and that as the appellants advanced their money upon the faith of that acknowledgement, they were entitled to recover against the defendants as makers of the notes whether they had been originals issued by their authority or not. The respondents on the other side insist first that Mr. Ox had no authority from the company to vouch for the authenticity of these notes. Secondly, that no authority could by law be conferred on Mr. Oxborough to give effect to an instrument as a promissory note of the company, which was not so in fact. And thirdly, that even if the notes had been genuine, the Supreme Court has no jurisdiction to entertain the present action against the respondents for the reasons stated in their printed case and combated by the counsel for the appellant. It is obvious from this statement that the foundation of the appellant's claim rests upon the assumption that the respondents have, through Mr. Oxborough as their agent, admitted that the notes in question were made and issued by them. And indeed, while it has been argued with great as it has been argued with great ability that the respondents are excluded by such acknowledgement from setting up any defense on the plea of forgery, it has been conceded that without such acknowledgement, the plaintiffs made out no case at the trial. Their lordships, therefore, have thought it right to consider this point in the first instance, and have been desired to declare their opinion that Mr. Oxborough's authority has not been sufficiently proved, and therefore that they forbear to call upon the counsel for the respondents to support their objections to the appellant's claim. The notes in question purport to have been made for and on behalf of the respondents by the Governor General in Council and to have been signed by his authority by Mr. Holt Mackenzie as Secretary to the Government, and this appears from the evidence to have been the invariable form of all promissory notes issued by the company in India. Without discussing, therefore, the question whether it was competent for the company to have made such a contract through the agency of any other persons, it is enough to say that there is no evidence of their having ever exercised such a power, and therefore, looking at the respondents in the light in which they have been viewed by the counsel for the appellants simply as a commercial firm, the Governor General in Council must be considered as the only agent authorized to make and issue promissory notes on behalf of the company in India, and the secretary to the government as the only agent appointed to sign them until some express authority to others be proved. It has been assumed, however, that the company has delegated to other and to inferior officers the duty and power of ascertaining and certifying the authenticity of notes submitted to their examination, and that they have thereby indirectly authorized another department to pledge the company's responsibility upon notes not originally made and issued by the Governor General in Council. Conceding for the sake of the argument that it was competent for company, like any other commercial firm, to delegate such a power to whom they pleased, and that the fact of their having done so may in this, as in other cases, in the absence of direct proof of authority, be collected from circumstances, it should require clear and cogent evidence to prove the improbable fact that they had reposed in an inferior officer the power of involving them in unlimited responsibility, not only by a fraudulent misrepresentation, but by an honest mistake or a careless inaccuracy, when they had guarded the original issue of the notes by such high and formal sanctions. In order to try the truth of this assumption, it is material to consider the time when and the circumstances under which this authority is supposed to have been conferred, and the nature of the evidence by which it is attempted to be proved. Mr. Oxborough professes to have derived it through Mr. Wood, the Accountant General, in 1824. It will be right, therefore, to examine his evidence upon this subject. First, let us see what were his duties before this time. In substance, he says it was his duty to register the number, date, and amount of each certificate brought to the office, and that thereupon a note corresponding with the register and certificate was drawn out, which, having been first compared and attested by the Deputy or Sub-Accountant General, was sent to the Secretary of the Government for his signature, and was afterwards returned to the Accountant General's office to be delivered out to the party entitled. Mr. Oxborough's duty, therefore, was to make and keep a register of the number, date, and amount of every note issued by the company, but there is not the slightest suggestion in the evidence that Prior to Mr. Wood's instructions in 1824, he had anything to do with the making, signing, or attesting the note itself. It appears from other parts of the evidence that about the year 1824, it was discovered that forged imitations of the company's paper had got into circulation, not as in the present instance in the form of exact copies of genuine notes, but in that of notes similar in appearance but varying in date, number, and amount, and the holders of notes became desirous of comparing their securities with the entries in the register, and it was at this crisis that Mr. Wood is stated to have given the instructions upon which the appellants principally rely. Mr. Oxborough in his evidence says, quote, I was authorized by the Accountant General to examine all notes sent by individuals, the Bank of Bengal or others, and to put my initials on them when examined. I was first so authorized in the end of 1824. Mr. Henry Wood was then Accountant General. He is now in England. I was so authorized by conversations, sometimes by chits. I do not recollect the words he used, but as far as I recollect, it was to examine the notes, to see that they agreed with our register, and to see that they were good notes. It was in the later end of 1824 that I first began to examine paper in that way. End of quote. Looking at the circumstances under which these directions were given and the manner in which they were conveyed and the nature of the instructions themselves, it is impossible to believe, without further evidence, that Mr. Wood intended that his clerk should, by affixing his initials to these notes, do more than certify that, upon comparison, they corresponded with the entries in the register. For, according to Mr. Morley's evidence, there was no suspicion at the time that this comparison would not afford a sufficient test. And although it appears that in 1828 it was discovered that by the fabrication of facsimiles of genuine notes, a closer inspection of the instruments had been rendered necessary, and that it was usual for Mr. Oxborough to subject them to other tests besides the comparison with the register, yet it is not pretended that he received any more extensive general authority from Mr. Wood. For he says, quote, from the first orders I received from Mr. Wood to examine papers in the way I have mentioned, there was no variation of that order until after the discovery of the late forgeries in 1829. End of quote. But it has been argued that the extent of Mr. Wood's instructions may be collected from acts of particular reference by him, and especially from a memorandum written across a note from Mr. Parker, in which Mr. Parker speaks of the authentication of certain notes, and Mr. Wood writes, quote, the examination of these notes is essential to protect the company from loss. Do them without fee. End of quote. From which expressions, coupled with the language of Mr. Parker's note, it is inferred that something more than comparison with the register was required, and that Mr. Wood evidently contemplated the liability of the company in the event of a mistaken opinion. But when it is remembered that the notes referred to in this memorandum were sent on behalf of the Salt Board, a part of the company's establishment, and therefore that the company would be the losers if they took in payment notes that turned out to be forged, the whole force of the argument vanishes, and the circumstance only proves that a servant of the company in one department was required to exercise, in protection of another department of his employee's business, the peculiar knowledge which his official duties conferred, and the other instances are open to the same explanation. I believe I have now alluded to all the direct evidence of Mr. Oxborough's authority from Mr. Wood, for he denies that the letter, under the sanction of which he took his fee, was the warrant under which he acted in giving out the certificates, and it appears to their lordships that the only authority given or intended to be given to Mr. Oxborough by Mr. Wood was to certify that the notes brought for examination corresponded with the entries in the register. But if any doubt had been left by the evidence upon which the appellants rely, it would have been removed by reference to the correspondence between Mr. Wood and the government, which clearly points to this as the only duty contemplated by Mr. Wood or sanctioned by the Governor General. It appears that on the 25th of June 1824, which was shortly before the date fixed by Mr. Oxborough for the earliest direction given to him on the subject, Mr. Wood, in a letter to Mr. Holt Mackenzie, wrote as follows, quote, I take this opportunity of submitting to the consideration of government the propriety of exacting from the public some fee for searching the registers of the government debt when information is required respecting the transfer of the proprietary right in the government promissory notes. The time of the uncovenanted assistance of my office is often inconveniently occupied. End of quote. How? In examining the notes to see whether the signatures are genuine? No. But, quote, in searching the registers for information connected with the government debt, and it is reasonable that the public should pay for the trouble they cause in the same way as they are now obliged to pay for any information they may require from the registrar of the Supreme Court, and I am of opinion that a fee of 1 rupee for searching for each note may not be thought too high. Should the government be pleased to sanction a fee of 1 rupee for searching the registers for each note, I would recommend its being paid to the uncovenanted assistant who has charge of the registers. End of quote. It is impossible to read this letter without being satisfied that nothing was contemplated by Mr. Wood beyond the remuneration to the assistant for increasing labor in searching the register, and that he had no idea of investing him with the new and responsible power of vouching in any other way for the authenticity of the notes examined. And the answer from the government secretary shows that the Governor General so understood Mr. Wood's object. The concluding paragraph is in these words, quote, the Governor General in Council approves and authorizes your suggestion that a fee of 1 rupee be levied for searching the registers for each note. End of quote. But it is further contended that although it may be true that Mr. Wood never intended to give Mr. Oxborough the powers he supposes to have been conferred upon him, yet that in fact he exercised that power, and therefore that as the Bengal Bank and the others might fairly conclude that the practice had the sanction of the government, the company must be responsible for the acts of Mr. Oxborough as their agent. If Mr. Oxborough had been found in the Accountant General's office publicly giving out certificates upon notes brought to him by persons anxious to ascertain whether they were genuine, without having any acknowledged duty to perform under which such certificate could be acquired, it might, with some color of reason, be contended that the company must be considered as authorizing a practice which could not have been unknown to them for the only intelligible purpose to which it could have been referred. But when Mr. Oxborough's situation in the office and his acknowledged duties to search the register and to compare the notes with the entries and to certify their correspondence are considered, the practice which is supposed to imply authority from the company to authenticate the signatures to the notes loses all its weight. Neither can it with justice be urged that the imposition of a new fee might mislead the public into the belief that it was required on account of some additional security afforded, for it appears that a copy of the letter authorizing the fee was hung up in the office, which would at once have satisfied anyone who chose to make the inquiry for what purpose the fee was required, and no instance has been proved of the companies having recognized Mr. Osborough's authority by acting upon his certificate, for according to Mr. Mackenzie's evidence, they never paid the interest upon the note without subjecting it to the scrutiny of two uncovenanted and one covenanted assistants, even though it might have upon it Mr. Oxborough's certificate. Upon the whole case, therefore, their lordships are of opinion that no authority was in fact given to Mr. Oxborough to authenticate the notes in question, and that looking at the formal manner in which the notes were invariably drawn and issued, the cautious examination the cautious examination of them before even the interest was paid, the known and acknowledged duties of Mr. Oxborough, the form of his certificate, and the avowed purpose for which the fee was taken, the company are not responsible for any erroneous opinion formed by Mr. Oxborough or the Bengal Bank as to the extent of his authority. Their lordships will therefore recommend to His Majesty that the judgment of the court below be affirmed, but in deference to the opinion of the learned judge who dissented from that judgment, that it be affirmed without costs. 7th and 8th February 1834 on appeal from Bengal. Babu 7th and 8th February 1834 on appeal from Bengal. Babu Beni Suhai and Babu Madhu Suhai, children of Masammat Setul Bahu, by their guardian Ramcharan Lal. Appellants Babu Harkishan Das, respondent. The Court of Sadar Devani Adalat of Bengal ought not to affirm a degree of a provincial court in a case respecting a balance of partnership accounts without examining the original account books of the firm if they are tendered in evidence before it, although they were not produced before the provincial court. The facts of this case are so fully stated in the judgment as to render any further detail of them unnecessary. The arguments on the part of the appellants principally turned upon the fact that the decree was made against Seetal Bahu without inspection of the books of accounts in respect of the balance of which the action was brought. And on the part of the respondent, it was urged that as Seetal Bahu had, to a certain extent, admitted his claims, she ought to have produced the original books of account which were in her own possession in due time before the court and arbitrators, and that although time had been given her to do so, she had never brought them forwards until after the decree of the provincial court had been pronounced. Miller and Wigram for the appellants, Spanky, Sergeant and Lloyd for the respondent. Vice Chancellor. It appears in this case that a partnership had been carried on between Harkishan Das, Dwarika Das and another person as bankers at Calcutta, which had transactions in various parts of India. The partnership was dissolved about 1797. Dwarika Das died before 1806, and on the 2nd of October 1806, an action was commenced in the city court, which was afterwards removed to the provincial court of Benares by Harkishan Das against the widow of Dwarika Das, who seems to have been then resident at Benares and to have represented her deceased husband for a sum alleged to be due on the balance of the partnership accounts. On the 24th of May 1808, the parties agreed by bond to refer the accounts to arbitrators. After some intermediate proceedings, the arbitrators made their final report about March 1814, which in effect stated a given sum to be due on balance of accounts to the plaintiffs, subject to certain objections, which it was stated could not be settled without an inspection of the joint concern papers of the Calcutta Court. There was some dispute on the question whether the original books should be brought from Calcutta, and shortly before the provincial court pronounced its decree, copies of the books were sent from Calcutta to Benares, but they were not proved to have been correct copies. The court, without allowing time to verify the copies or directing that the originals should be brought, proceeded to make its decree, which it set out in the appendix, page 40. Court ordered that the plaintiff's action is decreed to him and that he recover from the defendant Seetal Bahu the sum of 2,63,530 rupees 8 annas on account of principal and interest, which later has been awarded in an equal amount with the principal. The defendant to pay costs on the amount proved against her, and the plaintiff on the amount he has failed to establish, and that the vakil's fees be calculated agreeably to the former regulation, and upon consideration of the part the vakils of the city Adalat took in the case, it is ordered that they receive 1/4 of the fees and the vakils of this court three-fourths thereof. The defendant has the option of suing the plaintiff on the four objections she has advanced in this cause. End of quote. The defendant, after the decree had been pronounced, procured the original books to be brought to the Benares, and on the 5th December 1817 presented a petition for review stating the fact that the original papers had arrived, but the court declared there was no ground on which to allow a review of the case. On the 5th of May 1821, the defendant presented a petition of appeal to the court of Sadar Divani Adalat, calling the attention of that court to the fact that the arbitrator's report noticed the objections and that the original papers had been sent to Banaras before the petition of review was presented, and pointing out that by the decree, liberty was given to the defendant to sue the plaintiff in respect of the four items which constituted the objections. But the court of Sadar Divani Adalat on the 4th of July 1821 affirmed the decree, and on the 17th of November 1821 rejected the defendant's petition of review. Upon the face of the report of the arbitration, it appears that the accounts had not been fully taken and could only have been taken by inspecting the original books which were at Calcutta or verified copies of them. The provincial court ought to have postponed making its decree until either the copies had been verified or the originals had been produced, unless by some means it could have been satisfied that there was no validity whatever in the objections. But the court was not satisfied that there was no validity in the objections, for by its decree it reserves a right to the defendant to recover what she could upon the objections. It did for what she could, for by its decree it reserves a right to the defendant to recover what she could upon the objections. It did therefore in effect decide that a sum should be paid as the balance of accounts, although it is admitted that the sum to be paid might not be the balance, and that in substance no part of it might be due at all. Whether the provincial court could have admitted the use of the original books upon a review of the decree, it is not necessary to determine, but it is clear from the Regulation 6 of 1793, Section 16, that the court of Sadar Divani Adalat might have used this evidence to be supplied by the original books, but it did not do so, nor did it ascertain that the sum mentioned as the balance due, subject to objections, was a balance due without objection, but affirmed the decree as it originally stood. Their lordships are therefore of opinion that the decree must be reversed and that the court of Sadar Divani Adalat must proceed to ascertain what, if anything, was really due from the defendant to the plaintiff, having regard to the objections noticed by the arbitrators. Shit.